Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora, Wang. Today's topic is how do states make independent judgment in merger review, the Tunney Act and HPE Juniper. Joining me today is my co-host, Lexi Michaud. Hi, Lexi.
Hi, Anora. How's it going?
It's great. Can you do the honor and introduce our guest today?
I would love to. So today we have with us Anthony Mariano. He is the chief of the Antitrust Division at the Massachusetts Office of the Attorney General, where he leads the state's efforts to investigate and challenge anti-competitive conduct that harms consumers, workers, and businesses. Before that, Anthony spent over 8 years at the U.S. Department of Justice's Antitrust Division, including work on both civil and criminal matters involving competition policy and enforcement. He also previously served as prosecutor at the U.S. Attorney's offices for the Eastern District of Virginia and the District of Columbia. And prior to that, was an associate at Davis Polk and Wardwell in New York, where he worked on antitrust matters.
Well, great. Without further ado, Anthony, welcome to the program.
Thank you for having me.
Well, let's get to the point here. In recent years, we've seen state AGs play a more visible role, I think, in major merger investigations. From where you're sitting and your perspective, what role do state enforcers play in ensuring robust competition alongside the DOJ and FTC?
In civil merger matters or civil conduct matters, we're essentially co-equal enforcers. So for both merger and non-merger investigations, states have independent authority to investigate and litigate to stop anti-competitive conduct from taking place. So when a state looks at a particular transaction in the merger context, we really have two questions that come up pretty quickly. The first is this a transaction that appears to be problematic and should be a priority for further investigation by the Attorney General? And in many cases, that comes down to the priorities of the particular office. So in Massachusetts, we try to really focus on pocketbook issues, healthcare, housing, labor, other big costs of living that are driving costs for our constituents. The second question is whether this is a transaction where you can investigate alongside another state, another group of states, or a federal enforcer. And if our interests and priorities are aligned, those partnerships are great opportunities for us. But ultimately, we represent a separate sovereign and are conducting our own review, so we may not always be aligned.
I think you've hit the point already, but when federal agencies lead a matter, right, when they take the lead, states often still conduct their own analysis, even though sometimes you would join as say, a co-plaintiff with FTC or DOJ in active litigation. But even in those cases, you do independent state assessment. Why is independent state scrutiny such important for, for the whole U.S. antitrust regime to work?
Yeah, I think it's critical. We are happy, like I said, to be co-plaintiffs with our federal partners when our interests are aligned. And it's not just a benefit to us to do that, it's a benefit for our federal enforcer partners because state enforcers tend to be closer to the communities where the competitive effects may be felt. We may have a greater ability to develop relationships with potentially affected consumers or employees. So it's a real value add for the federal government to partner with the state enforcer. But like I said, there are cases where our interests don't align. And at a given time, the federal government may be more or less concerned about increasing consolidation across the economy. So independent state enforcement can provide more stable and consistent scrutiny of potentially harmful transactions than federal enforcers might.
Obviously, as an enforcer, you take every matter seriously, but we see you don't, like you as a state enforcer, you don't engage or actively engage in every case, right? What state-specific considerations are there that would typically motivate a state's decision to actually try to sue to block a merger alongside the DOJ and FTC? What do you think?
So it's really going to vary state by state. Every state is going to have their own priorities. Like I said, in Massachusetts, if it's a pocketbook issue that really affects cost of living, that immediately goes to the top of our priority list. Across the board, states are focused most on the effects that are going to be acutely felt within their local or statewide economies, and obviously less so if the effect is more pronounced in other states where we don't have as much of an interest. So given that where the DOJ and FTC have historically been leaders is on those larger national mergers, those that don't affect one state or a handful of states much more than any others, they're historically, just as a matter of resource allocation, the states have tended to rely on the good faith of DOJ and FTC to protect competition in those transactions. And we rely on that even when we don't necessarily partner as co-plaintiffs on the outset. There are cases where DOJ is doing it on behalf of the entire country, and we rely on them to protect our interests as well.
Anthony, I think that's a good segue to talk a bit about the legal guardrails around DOJ and FTC settlement review. So for listeners who may not be already knowledgeable about this area of the law, can you tell us a little bit about what the Tunney Act is and how the Tunney Act helps promote transparency and accountability in merger enforcement?
Yeah, the Tunney Act is one of the principal means by which Congress has sought to ensure that federal antitrust enforcement occurs on the merits, free of corruption and political favoritism. And it was put in place in the 1970s following allegations that actually the Nixon administration had settled a merger challenge for corrupt purposes. So the principle behind the Tunney Act was to require an independent review of any proposed federal antitrust settlement with the DOJ to ensure that the resolution was on the merits and in the public interest generally. So essentially, the Tunney Act imposes some procedural requirements on the merging parties and on the United States before the court ultimately approves the settlement. So the United States needs to publish the proposed consent judgment on the Federal Register and in newspapers and accept comments for at least 60 days. The United States then needs to consider and respond to those comments and do so publicly. The United States has to disclose and evaluate any alternative remedies that they actually considered as part of the settlement back and forth. And the merging parties need to disclose and describe the written and oral communications that they've had with the United States regarding the settlement. The exception is if it's just between the lawyers, that doesn't need to be disclosed. But if it's lobbyists or executives, that has to go into the public record as well. So once all of those steps are taken care of, then the court needs to determine that the settlement is in the public interest. And to do that, the court needs to assess both the competitive impact of the settlement and the impact of the settlement on the public generally, including if there would be a benefit to be derived from resolving those issues at trial. And that goes back to the significant public interest in preventing settlements that would be based on political favoritism or cronyism rather than on the merits. So in making its public interest determination, the court has a lot of flexibility. It's empowered to allow intervention or allow amicus participation, to allow discovery, to take live testimony, even of government officials, to appoint or bring in and hear from experts. But ultimately, the court has really wide discretion to try to get that ultimate public interest determination right.
So you touched on this a little, but the Tunney Act process, from the sound of it, is mostly driven by federal agencies. So how do the states interact with the Tunney Act process? What are the most relevant considerations for states on how to participate in merger settlements or related proceedings when it comes to the Tunney Act process? So the states have a number of interests in the same way that a number of parties who might object to a settlement may be interested. But let me highlight our two primary interests. The first is the interest in making sure that there is a settlement on the merits that makes sense for our constituents. And there we have the same interest that our constituents have, which is to prevent anti-competitive transactions from taking place and harming those in our states. Obviously, the United States can take action to enforce federal antitrust laws, but like I said earlier, the states are separate sovereigns with
independent enforcement authority, and we independently review transactions and need to protect our states. The second interest is in making sure that the federal government is reaching an antitrust settlement that is in the public interest generally. And that goes back, obviously, to the marriage piece, but also to that piece of preventing corruption and political favoritism from taking over the merits and having settlements that really shouldn't be reached in the first place. And notably, these interests that the states have really line up very well with the interest that the court has in ultimately making that public interest determination.
With that helpful discussion of the Tunney Act in the background, I think we can build on that and really focus a little bit on a recent matter where states have become more involved in the Tunney Act review and the related litigation, which is the HPE Juniper transaction that we have included in our title today. Can you tell us a little bit about this case at a high level for people who are not already following closely?
Absolutely. And I'll note this is an ongoing matter, so I'll, of course, restrict anything I say to what's already in the public record. So this case involves the acquisition by Hewlett-Packard Enterprises of Juniper Networks. And in January 2025, the United States sued to block that merger, alleging that it would result in a substantial lessening of competition in the market for commercial enterprise wireless networking solutions across the United States. That's a mouthful. I'm not a technical expert, but enterprise wireless networking solutions is basically the suite of hardware and software solutions and systems that facilitate an extended wireless network across, say, a college campus or a large corporate campus or a hospital system. So the United States identified HPE and Juniper in their complaint as the second and third largest competitors, respectively, in that market, and alleged that post-merger, the two largest competitors, which would have been new HPE and Cisco, the market leader, would have a combined market share of over 70%. So the DOJ alleged this was unlawful, citing theories of harm from both unilateral as well as coordinated effects. That case was ultimately set for trial on July 9th, but about 2 weeks before that, the parties reached a proposed settlement. And the settlement itself, rather than requiring divestiture of the overlapping business, which is what you often get in these merger challenges as a suitable remedy, it required the divestiture of a very small part of Juniper's business, a component called Instant On, as well as the license of the source code of Juniper's AI product, which is called Mist.
What roles are the states currently playing in that case?
So the settlement was proposed in late June, just before trial. And then by late July and early August, there was significant public reporting coming out that HPE had been able to secure this settlement by hiring lobbyists that had close ties to the federal administration, and that the settlement was reached over the objections of the career staff working on the case and even the political leadership of the Antitrust Division. And in fact, none of the DOJ trial staff who were working on the case signed those settlement documents, and even two of the political appointees within the Antitrust Division were fired shortly after that settlement. So that was in early August, and then in late August, mid to late August, 2025, former Principal Deputy Assistant Attorney General Roger Alford gave a public speech where he characterized the settlement that was reached in this case as a scandal, a perversion of justice, and inconsistent with the rule of law. And listeners should read that speech if they haven't already, but I'll quote from it just briefly. Quote, "Although the Tunney Act has rarely served its intended purpose, this time the court may demand extensive discovery and examine the surprising truth of what happened. I hope the court blocks the HPE Juniper merger. If you knew what I knew, you would hope so too." So in light of the terms of the settlement and all this information coming out, a number of states, including Massachusetts, worked quickly to make public comments objecting to the settlement, and then ultimately moved to intervene to participate in the Tunney Act proceeding. And the states, fortunately, were granted intervention. So now we're participating in the case as parties in the Tunney Act proceeding. So we are taking discovery right now. There's an upcoming hearing where the court will make its public interest determination on the settlement, and we'll be participating in that. And we're doing all of that for a number of reasons. We have to protect our constituents from any anti-competitive effects from a merger that was wrongly allowed to proceed. We need to help bring sunlight to the settlement process and expose any possible corruption. And because the DOJ and HPE are now sort of aligned behind the settlement, we're there to help ensure that the court has the benefit of a truly adversarial process so that it can make an informed decision about whether the settlement's in the public interest.
Anthony, can you tell us a bit more about the core competitive concerns of the states with the merger? So you referenced that the division's complaint cited to a 70% share combined for Cisco, HPE, and Juniper. And there are some unofficial sources, albeit, that contradict that and say that Cisco is the clear winner there and that HPE and Juniper have less than a combined 30% share, so less than the presumption. Can you tell us a bit more about what the state's core competitive concerns are from that perspective?
Sure. And again, I'll restrict myself to the public record and speak at a general and high level. What the public record shows is that DOJ in its complaint and in its pretrial filings had put forward evidence establishing a structural presumption under the merger guidelines, and that DOJ had a clear prima facie case. Even beyond that, what the public record also lays out is significant evidence of head-to-head competition between HPE and Juniper. That included in the complaint that HPE had various initiatives to, quote, beat Mist, referring to Juniper's product. It had a beat Mist listserv to share competitive intelligence. It had a beat Mist training program for its sales executives. And HPE in its internal documents was talking about, quote, head-to-head street fights with Juniper. And there were allegations of significant evidence of those head-to-head bidding competitions where customers were benefiting from significant discounts because of that head-to-head competition. So all of that, beyond the sort of statistical prima facie case, that's the kind of evidence that really is the gold standard of what would raise serious concerns about the elimination of head-to-head competition. In addition, the allegations are that Juniper was an innovator, a maverick, and that its market share was growing over time. So when you eliminate a successful, growing, and innovative competitor, that's on its own really harmful to competition, and that's a major concern as well.
I want to hone in also on something else you mentioned. So the states in their public filings are obviously asking the court to scrutinize the substance of the settlement, but also to look at the process that led to it. So including, like you mentioned, the alleged back-channeling lobbying. How at a high level do states see their role in raising concerns about process, not just about structure here?
So this is really important because you can't separate the process from the substance here, because what the states need, what our constituents need, and what the Tunney Act demands is that merger enforcement be apolitical and on the merits. And if deals are getting cleared through the Department of Justice because a company has hired the right lobbyist with the right connections, or the company is a political friend to those in power, then that is fundamentally not a decision on the merits. So once a settlement is, or a proposed settlement is reached, any good lawyer is going to be able to find a way to articulate how that was somehow the right decision all along on the merits. But if in fact that decision came about because of political favoritism or connections, that decision can't be in the public interest because the process by which it was reached was corrupt and rotten. And it undermines the rule of law, not only in that case, but in the next case and the one after that down the road.
To start to wrap things up, Anthony, we want to ask you to look ahead and to tell us a bit about what you expect states to play as far as their role in the future. So are they going to play an even greater role, an even more active role in merger enforcement going forward? Or what forces do you see driving that trend? What changes do you see in the upcoming months and years?
I think there will continue to be an increased role for state enforcers on merger enforcement. And states have been active historically, but I think now, perhaps more than ever, vigorous and apolitical antitrust enforcement by the states is crucial. Given what we've seen and has been alleged from DOJ in the HPE matter, as well as other recent public reporting, there are serious questions about how the DOJ is making its antitrust decisions right now. But businesses need to know that if the DOJ is going to abandon the field on merger enforcement, the states are not going anywhere. To be clear, I'm not offering any criticism of the career men and women of the Antitrust Division, the attorneys, economists, paralegal staff. I have full confidence that they are trying to follow the facts and the law and the merger guidelines to protect competition. But what the public reporting is telling us, if it's to be believed, is that they are being stymied in their work by a federal administration that appears more motivated by political cronyism than by the merits of the cases in front of them. And if that is what is happening, businesses should know that getting their deal past DOJ is one step in the road, but it's not the end of the road. The states are here to independently and apolitically protect markets through vigorous antitrust enforcement, including and in particular in merger matters.
Well, thanks for that discussion. We try to perhaps end the discussion with a lighter note and with a little bit of like personal flavor so that our listeners and viewers now get a chance to know you, not just as an enforcer, but also as a person a little bit more. So can you tell us a little bit about yourself? Maybe just share one thing that people would not have known you if they had only known you or worked with you professionally. What would that one thing be?
So if you only knew me as an antitrust lawyer and you saw my name, you would probably be able to figure out that my heritage is Italian-American. But I am also Greek-American on my mother's side. And in the past couple of years, I've gotten much more into Greek cooking. So moussaka, spanakopita, baklava, and experimenting with different ways to cook all of those. So this is a little work related because I'll use it as a recruiting pitch. Anyone who's looking to come to the Massachusetts Attorney General's office, I'm regularly making trays of baklava, as my colleagues and former colleagues know, and bringing them into the office. So that is a potential unofficial and unannounced perk of the job that people could get access to.
Now you have announced it at OCA. I think it's official now. It's not even just a thing that you can just casually offer. Now you have promised. Lexi, you have something else to ask?
Yeah, Anthony, my question for you is related to what I'm looking at in your background. I see you have some version of a Monopoly board game. Can you tell us a bit about, I think I know why it's there. I like the pun, but can you tell us a bit about its significance for you?
So lots of public antitrust enforcers have the anti-Monopoly game, which I still need to get my hands on. This is the Worcester edition of Monopoly, which came out a few years ago. So I'm originally from Worcester, Massachusetts, born and raised. I'm contractually obligated to say it's the heart of the Commonwealth. It's the second largest city in New England. And growing up, being in Worcester was important to me. It's a great community. My father was in public service there for decades, including serving as mayor. So I was grown and raised to really have a love and appreciation for Worcester and to always promote it. So a few years ago when the Worcester Monopoly came out, without any coordination in advance, my father and I both independently bought the game for one another as a gift and exchanged it Christmas morning. And we're surprised that we had each gotten it for each other. So I like to keep that in my home office, given the importance of Worcester to me, as well as its overlap with my work today.
And do you ever have an opportunity to play it together?
It is strictly a display piece. We have not played it.
Good to see so much competition-themed things are going on in your house. It must be a fun house. Thank you so much for joining us today. And I think we've learned a lot on some things and about you as a person. We hope to get you back perhaps in the future to talk a little more about state enforcement in general. And then listeners and viewers, until next time.
Thank you for listening to this week's episode of Our Curious Amalgam. a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.